Live streams are up. Recording has started.
Okay.
We're not on the radio yet, though.
All right. Are you going to speak on the radio, Hal? Or
I don't need to.
Oh, no, we're on.
Oh,
we're live. Hey, we're live. My name is Richard Fields with the Greater Houston RIA and the Alamo RIA. Welcome to the Massive Passive Show and podcast. Changes are happening at the Massive Passive Show. In the last 6 months, we have been in the process of opening up what we think will be the most impactful RIA group in Houston. We're excited about what we're doing. We invite you to join us at one of our 2 RIA groups. The first one in Houston, the Greater Houston RIA. We meet the second Saturday of each month at a central location on the West Loop. We will soon outgrow that location. We are grateful to Transact Title, who has been a gracious host. They're also a terrific title company and one of the vendors sponsoring this radio show and podcast. In San Antonio, join us at the Alamo RIA. We meet the second Tuesday of each month at the Alzafar Shrine Auditorium on Loop 1604, just east of Blanco Road. We're excited to be at that facility with room to grow, and we do plan massive growth. And we are launching an umbrella organization we're calling the Lone Star RIA. Much of it is just an idea on paper, but you can find all our sites at lonestarria.org. You'll find links there to the Greater Houston RIA, the Alamo RIA, and the Massive Passive Show. You can also find us on Facebook. Much of what we have is new, but the excitement will catch on, and we want you to grow with us. Today, I'm pleased to have landlord attorney Ernie Garcia with us. Ernie came to raise attention last month. I think he heard you on a video or a podcast, and he knew right away that we wanted you to come to our group. And you came to our group. Ernie, thanks for your tip of the month at the Greater Houston RIA last Saturday. We liked you so much. You're our featured speaker at our June 11th meeting. For anyone who owns a rental, you won't want to miss that. It will be educational, and after hearing Eddie, it'll be informational and inspirational. He delivers, that's all I can say. So with the COVID turning from a pandemic to an endemic and the moratorium lifting, there's quite a mess out there. I remember sending out postcards to landlords last year looking for buyers in central Alabama. We sent 300 postcards out, and nobody was buying. Most everyone responded wanted to sell, and it was a higher number than usual. Ernie, I imagine you see a lot of tired landlords these days. Houston's not like a small town in Alabama, but you have to see many landlords feeling like the ones I ran across here.
Yeah, it's true. There's lots of landlords out there, new and seasoned landlords, and they've experienced all sorts of issues from this pandemic, and so we've had to adjust to the changes of the law and the changes of the situations that these landlords have found themselves in.
Wow. So if any tired landlords out there listening to this and you need relief, you can go to lonestarria.org and join with us. Or if you need legal advice, you can go to Ernie's website. It's easy to remember. It's attorneyeg.com. Again, that's attorneyeg.com. Ernie, I see on your site you can sign up for a 30-minute Zoom call for a reasonable fee. So check it out, attorneyeg.com. So with the preliminaries out of the way, let's go to our topics. We have 3 of them. These will be fast-paced. We really want to get through these topics, so I'll just skip the introduction on your on what qualifies you and just jump right into it. When we get to our material, you'll know why I'm doing this. His knowledge and skills in the law and helping people speaks for itself. So let's roll. Ernie, while I'm not going to go down your resume and qualifications, can you tell us the basics, like, what do you do in your practice, your office location, geographical area served, things like that?
Sure. So a majority of what we do is real estate. We represent both commercial and residential landlords in real estate matters having to do with evictions, having to do with other litigation in courts, repair and remedy cases, security deposit disputes. But we also represent parties involved in foreclosure matters, having to do with the county, having to do with notes, and then other disputes having to do with real estate, buy-sell agreements that kind of go sideways, or matters having to do with earnest money disputes. And then non-real estate, we handle some consumer and commercial debt. Our office is located here in Houston. We are right by NRG Stadium, and we get to enjoy the rodeo all the time now. But we're located at 2626 South Loop West, Suite 630, Houston, Texas 77054, right off of 610, right near NRG Stadium. And as far as our geographic reach, we serve clients all over the state of Texas. Our primary focus is Houston, Harris County, and the surrounding counties here, but we've represented clients all over the state.
So before we go to our first segment, I'm sorry, I'll read it right now. So the first segment that we have is basically coming on three statements that Ernie sent me. This is the first one, and it is: tenant screening can make or break your landlord-tenant experience. Again, I'll say tenant screening can make or break your landlord-tenant experience. Before we go into that statement, though, I really have to mention a national vendor that we have. It's a benefit that our RIA brings to its members. Rent Perfect is one of our most important national vendors. It's designed specifically for landlords. Ray Sasser considers them part of his team, actually. He likes them a lot. And so if he were on this program, he'd be waxing eloquent about that. I've heard him do that a number of times. But if you're a landlord, I want to point you to focus groups that we have for the RIA. These are investors that get together and they talk about the same kinds of things we're going to talk about this morning, what they're doing, what resources they have. But Tuesday, March 29th in Houston, and then it'd be Monday, March 28th in San Antonio. We have our landlord focus group meetings in both Houston and San Antonio. You can go to our website and find that out, lonestarria.org. We have links to those sites. You will find these events listed and you can sign up. Because of the National RIA, our landlords have benefits that can help with what Ernie's going to share here. And I think I have more to say about that. So Ernie, speak to that statement. Tenant screening can make or break your landlord-tenant experience.
Sure. So, we see all sorts of problems that come into the office from the landlord perspective, and they come to us as problems. What I'm talking about today is a way for landlords to prevent these problems from ever occurring. And one way is when we look backwards in time at what went wrong, we notice that the tenant screening part of the evaluation of a tenant is what was lacking. Had a landlord, for example, done a credit check, oh, they're a nice guy, they were referred to me by a friend, and so you skip the credit check, and you could have found out earlier in the process that a simple credit check would show that the tenant that you're looking to reside in your $2,000 a month property could never afford that, or has had a hard time paying their bills in the past, and so they might not be a good fit. So, a credit check is essential. And if you can find a company that can run credit, employment, rent history, even criminal history, that's a key strategy to ensuring that the tenant you have in place is qualified to be there and will ultimately be a good fit for you long term.
Yeah, so Rent Perfect is one of those sites. There are others, but again, as a RIA member, you would get a discount on that, and you might also be in a community that's using the same platform. There's some advantages to that. So you mentioned credit and employment. Did you mention rent history and going back on that? And then I'm wondering, is it possible to contact previous landlords if that's something that you're asking, or can you do that?
You absolutely can. So in terms of rent history, this would include any check for prior judgments that were issued against a tenant. Sometimes just a simple check of court records, and depending on the company that you use, they'll scour court records looking for these names. If you have a name match to a prior address or a prior landlord, you might find that someone has been evicted multiple times, and that should be an automatic red flag for you. In terms of reaching out to previous landlords, there's this kind of a tricky situation, especially to the most recent landlord, because imagine a landlord who is really anxious to get rid of a bad tenant. They might say whatever it takes to make sure they're not having to deal with them anymore. So I would take that reference with a grain of salt. I would actually suggest that you call the landlord that was previous to the last, if you can. Your tenant doesn't always have that, but if they can't produce a decent rental history, a reliable rental history, again, red flag.
Right, and something practical that they can do if you're in real estate investing, it's pretty easy for us to go back and find the property owner. That's just tax records, and so if they can give you that address of that previous spot, I can just see the unsuspecting person getting duped. In fact, I had that experience as an employer one time. I called someone, and they were just very glad to give me some really good information on this employee, and it was not that at all. So, wow. Are there any other people that you find that are just unaware of something like tenant screening? Your first impressions. I pride myself on being able to judge someone's character.
Sure.
And I've been burned. So yeah, tell us a story. It sounds like you have something.
No, absolutely. The tenant screening that tends to, bite a landlord in the rear is the kind of screening that never happens. So you might find a very qualified, very capable person who signed a lease for whom you've done a thorough background check. All the boxes are yes, A+ for this guy, but they're the only ones you checked. Mm-hmm. And it turns out multiple other adults are residing on the premises. But because you got that one winner on the lease, you decide, I'm done. That's a poor way of screening. You can't just screen the best of them. You have to screen the rest of them. And if you don't, you're going to fail. Because what may happen is that person who filled out the application may not actually even reside on the property. They're there as a shield to the really terrible tenants who will actually be on the property. By doing an incomplete check, you're doing yourself a huge disservice.
Wow. And when you say get all of them, there's probably some legal reasons that they'd want to do that, for discrimination laws and things like that. Is that a concern, or?
No. I mean, if you are applying your standards, right, you need a certain credit score, you need a certain employment record, you need a certain criminal history record, you need a certain rental history, I've actually created what I call a tenant scorecard. And so landlords can use this. You can actually download it from my website. You can use this tenant scorecard and assign a point value to each of these things, and you decide, well, what's a passing grade for me? And as long as you apply this strategy equally to all of your prospective tenants, you're not going to run afoul of this kind of discrimination claim. But in terms of getting all the adults, you want your lease to have every adult who will reside listed on your lease. In fact, you want all persons named. If they're minors, they're occupants. But if they're adults, they are tenants who will sign and obligate themselves to this lease. That should be hands down the absolute approach. Too many landlords come to me with leases where one person signed as the tenant, but 4 other adults are residing there, and that tends to spell trouble. There's a reason that these adults are not subjecting themselves to screening, and it's usually a bad one.
Wow. I'm just thinking about, Yeah, I have to admit that my wife, who's a realtor, has handled all of our rentals and is much better than I am. And I'm just very glad that she was going through some of this. But I'm just thinking now about how that could really bite someone. Oh, I got a roommate. And they just never get on, but you want them on that lease, actually.
Absolutely, absolutely. Because if, let's say, the primary person skips out and only the roommate's left behind, you can't get a judgment against that roommate because that roommate didn't sign the lease and is not subject to any of the terms. In any eviction proceeding, you would actually have to sue the original signer. That's the only way to legally proceed if you intend to collect rent. Right? They are still obligated. And so if everyone's on the lease, then everyone is equally obligated, whether one skips out early or not.
Wow. And a little bit later, we're going to be talking about the lease, but wow. So the tenant scorecard, tell us a little bit about what went into that. I mean, is there a story behind it, or?
Well, I mean, it's compiled of my years of experience dealing with the kinds of problems that are easily anticipated that we see a mile down the road if we have the data. And too many times landlords kind of, they'll come to me and say, Ernie, if I'd known better, I would not have gone down this way. And so you kind of retroactively, what would you have done in this situation? And so over the years, these are the 10 topics, and the scorecard lists all 10. And you can give each, its own corresponding value as to its importance to you. But yeah, it was compiled from years of hearing landlords talk to me about problems that could have been foreseen at the application process.
So anything else you want to talk about on the tenant screening can make or break your landlord? I just make or break. And so it's really critical that you can do make or break. When I hear that, there's a few small details you can take here that's going to turn this into a success rather than a disaster.
Absolutely. One that happens way too often is I see landlords who are willing to take on a new tenant who can't quite pay the first month's rent and the full deposit. That also should be a huge red flag that the tenant simply cannot afford the leasehold. If they need time to pay these, and you might stop and say, well, Ernie, that's a lot to ask for a new tenant. It should not be a lot for you to ask a tenant who you have confidence in, whose money is well enough to sustain them throughout the entire lease term. If they're having trouble right off the bat, that's a sign that they probably are not a good fit.
Wow. I had a contractor friend tell me one time, I said, Richard, it's easy to get easy, but it's hard to get hard. Can you maybe speak to that in the landlord business?
Sure. We tend to sometimes see the best in people. And so, well, we're going to cut you a break here. We're going to cut you a break there. But every time you give an inch, you're losing money. And if we're going to get to the business side of things a little later, but if you can't treat this like a business, you're probably not in the right field. And so you got to be able to hold your tenants to the letter of their agreement and anticipate that if something's going wrong, something else will follow. Something else will go wrong.
Wow. So I got a final question, but I'm going to hold off on that because we are going to do a bonus segment here. It's only going to be available to RIA members. And so you can go to lonestarria.org and find out about membership. And when you do that, you can go to our membership site, log in, and you'll be able to get that link there from the bonus material. And I got to write that down real quick. Ernie will remember here because we'll do that. Anyway, by the way, this is the first time we've had this new format here, and I'm just doing the best I can right here. My wife got onto me because I'm reading my script here, and those on radio. We're live on YouTube and Facebook, so y'all might be able to see it, but here we are. That's what we have for segment 1. We'll come back for segment 2 and another statement in a moment. For those listening to this, Ernie will be our featured speaker at our June 11th meeting at the Greater Houston RIA. And we didn't talk about this, but James has been talking to you about coming to San Antonio. And so
Yep.
we'd love to have you over there at the Alamo RIA. So let's hope that all works out. So I'd like to take a second to talk about one of our vendors. And today I want to talk about Lucas Cedar. I believe it was Mike from Lucas Cedar that was at our event last Saturday. They're an early sponsor of the radio program and now the Greater Houston RIA. Their office is in Willis, north of Houston. If you're looking at an application, whether it be an interior or an exterior application, for some extra pop and value for your rehab job, or if you're wondering if using Cedar would cost you more, give them a call. They'll be able to tell you that. You might be wondering what difference Cedar could make in your project. They know of jobs all over Houston that you can go and look at and judge for yourself. With current buyers demanding what I call HGTV standards, you might find Lucas Cedar can help you add tremendous value to your project. You can find them on the web at lucascedar.com. That's lucascedar.com. So now we're ready for segment 2.
One thing real quick. You mentioned that he's going to hopefully be speaking in San Antonio. We didn't actually get the areas he does work in. Which parts of Texas are you currently practicing your property law?
You said all over Texas. Do you
Right.
mention San Antonio?
So we've handled some cases in the San Antonio area, the Austin area, as well as Dallas. Now, we don't practice as much in those outside markets as we do in Houston. Our primary practice is in Houston, Harris County, and the surrounding counties here, Brazoria, Galveston, Montgomery County, Fort Bend. But our reach does extend, and we're hopeful in a short amount of time to actually open an office in the San Antonio market. But we're just not present there yet. However, our reach does extend all over the state of Texas.
Good deal, and especially in commercial and apartments,
Right.
I imagine. Mm-hmm. So we're ready for segment 2. Again, go to lonestarria.org to find, to find us. To find Ernie, go to attorneyeg.com. Now, Ernie, you gave me the statement, a bad lease is worse than a bad tenant. I'll say it again. A bad lease is worse than a bad tenant. When you sent that statement, I thought of the whole landlord-tenant relationship a little bit differently. I thought that I knew that a lease is part of that relationship, but I never really felt like it was a foundation, like a foundation to a building. So with that, I bet you have some other things to say that can change our thinking about the whole enterprise of being a landlord.
No, absolutely. You find it funny because I read leases all the time, and I look back to when I was in college, I never read my lease. I had no idea what it said, not really, and most people are that way. We don't read our agreement when we sign up for our cell phones. We don't read our agreements when we download new software. We're just click, 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 and we're ready to go. And most people treat their leases that way, including landlords. You don't know the power you have because you haven't studied the power you have. And if your power is lacking, it's probably because you've got a bad lease.
So I got a few questions here. What are we looking for, getting back to in good behaving tenants that also pay their rent on time? Mm-hmm. I know that we've been guilty of this, of cutting someone some slack on the payment, and the payment only. Otherwise, they're a great renter, but then those that always comes back to bite us, it seems. And you had a lot to say last week in your short tip of the month that you gave us at
Right.
the RIA meeting. But what can you tell us today?
Well, it comes down to the expectation that you set as a landlord for your tenant. If you set an appropriate expectation for timely rent payment, then your tenant will likely rise to that expectation. And if they don't, you can use that same lease and its provisions to transition away from that tenant, mostly through the eviction process. But you have to be willing to do both. You have to be willing to utilize your lease in a way to set a very clear expectation. It's not, well, whenever you can pay me, that's fine. Well, the lease says something more precise. And then when that tenant simply cannot meet that standard, you have to make an executive decision to protect your business, to protect your asset, and begin enforcing the terms of that lease so that you are protected and that you separate yourself from a tenant who, even after proper screening, now presently cannot sustain their rent obligation. You have to be willing to pull that trigger and be willing to do it early as opposed to late.
So if you sign a lease with someone, and this is a general attorney type question, can't I get in trouble with one of my tenants if I choose not to follow the written agreement and make an allowance for this, because then that could put in jeopardy some other things? Or how does that work as far as, you have an agreement, you really have to follow that agreement. And if you don't, you really need to amend the lease to say where you're not following it, because you can then give up some other legal ground that you might need to fall back on. Can you give us an example of that?
Sure. Now, most leases, many leases, in fact, the best leases have what's called a non-waiver clause, which in its most basic form says, just because I didn't exercise my rights earlier on in the lease term doesn't mean I can't later exercise those rights. Now, that's what it says in black and white, and that's a great term to have. However, there are some courts who won't honor that. There are some courts where if you say at the end of a lease, well, now I want to enforce X, Y, and Z, but the judge, especially in the justice court, which are courts of equity, they're out to determine fairness. That judge may say, I'm not going to let you enforce this because your course of performance has been to let it slide and let it slide and let it slide. And now you're coming to me to enforce a term that you let slide for 2 years. Sorry, landlord, it ain't happening. And so I've seen courts disregard non-waiver because your performance was to waive. Things went sideways, and now you decide, well, this is the way I'm going to enforce my lease. And the judge says no.
Right. So I kind of think of, I heard this in church about, tell them what you're going to tell them, and then tell them what you told them.
Right. And if you're consistent from beginning to end, you're going to have a much better relationship because, as I stated, you set an expectation, they will likely rise to that expectation. If you set none, then they're going to meet you right there at no expectations, and they're going to run it as they see fit. But as a good landlord, you want to establish a benchmark for what's acceptable and what's not, and then stick to it as well. Show the tenant that you value your lease and its terms as much as they do. And you're going to have a much better experience if you hold them to the terms of that lease.
Well, and I guess communication is key, and getting back to if you have a mooring of knowing what's in your lease, and you don't have to like master the whole thing. It's just the key points. And again, I mean, we're encouraging you to join AREA if you're a landlord, and come to our landlord group meeting, and that's where. And in community, there are people that you can pick up and call, and they've been through those experiences. And the biggest value in those experiences, and you've seen this very well, is that if you study your colleague who is suffering,
right,
then you can basically take on that suffering with them in a way and experience that, and then purpose never to be in those shoes again. And so you're going to go back and read your lease, and you can avoid a lot of pain. So join your RIA. So you've mentioned elements of the lease, and we kind of touched on that about certain things that are in certain leases. So I got like 2 questions here on elements. What elements of the lease are must-haves? They got to be in there.
Right. So there's a few. I'm going to touch on a few here. The first is an application of funds clause. And what this clause allows you to do is to take in any payment and apply it first to any fees that are outstanding. Generally, this is for late fees. So you might be in the middle of March and you finally get payment. And so late fees are due. Maybe there's a broken window and your lease requires that for the negligence of the tenant, they're required for those to cover the cost for those repairs. And maybe there's some other matter. But on their check, they note in the memo section, rent only, no fees, I'm serious. And you go and deposit that check. Are you bound by the note in that memo? Not if you have an application of funds clause. Generally, the memo is virtually meaningless in this kind of transaction. But that application of funds clause allows you to take the money that you receive, which your tenant has designated as rent only, but who has agreed in your lease that you can apply that money first to unpaid fees and other charges that are owed to you by virtue of that lease, leaving a rent balance. At that point, what I would suggest is sending a notice of default and say, you still owe X amount in rent, to which they'll reply, no, I paid my rent. In fact, I ordered you in my check to apply it exclusively to rent. You'll point to the application of funds clause and say, you ordered first that I could do whatever, apply these funds in whatever way I saw fit, and I applied them to fees first. Please pay the rest of your rent balance. And by the way, here's a notice to vacate for non-payment of rent. And so again, you establish the expectation based on what's written in your lease that whenever payments are made, you can apply them in a business manner that makes sense for your business. Applying it to rent exclusively and perhaps waiving these other fees, not a good business decision.
Well, so we have bought several houses this year that had a tired landlord, and we get into it and we ask about the lease. And we just find out that they were just so tired, they were beleaguered, and in one case, we bought the house sight unseen, and now we're evicting the tenant who claims he owns a house somehow. And
that happens, yeah.
Yeah, and it's happening right now on a case that we have. Of course, we knew that going in, and so we're prepared for that. But I just tell us some stories. You had a lot to say last week. I felt like, to the unsuspecting landlord, or the landlord that the one that I'm trying to remember exactly what that was, but the one that was, I think, reticent to communicate with them, and you're encouraging them, just go by the book and do it with a smile. It's like one of the best things you can do is hold your tenant to the lease, and this is for you and them,
right,
so that it's got a good outcome. So speak to that.
So I'll talk to something that probably most property owners, anybody who was around in the state of Texas last February, has some kind of experience with the big freeze. Right, we don't get that cold in Texas, but February of last year, 2021, we had the big freeze. And one of the issues that was common to a lot of landlords was this busted pipe issue. And we had a few landlords who would come to us and say, Ernie, I'm trying to get in. I'm trying to be a good landlord. I'm trying to get things fixed. My tenant won't give me access to the property. And for each of these, I would point the landlord to the lease. Take a look at your lease. What does it say about access to the property? You don't need your tenant's permission in most cases. In most cases, especially on an emergency basis, you don't even need to give them notice that you're coming. You just come in and fix your property. But too many landlords don't know this. They don't know that they already have the right to enter, especially when it's about an emergency. Now, for a few of these, and you talk about specific cases, for a few of these, it was a matter of hostility, where tenants would make threats and say something to the effect of, if you come into my house, I've got a gun, and I might just use it. You are not allowed into my house. Now, in Texas values privacy. Texas values the home, and Texas values the right of people to carry their a firearm, especially in their home. But Texas does not allow a tenant to unilaterally exclude a landlord. And so, especially in the event of an emergency, a landlord's allowed to come in. The problem that's caused here is the landlord must enter, if he or she is going to enter, peaceably, reasonably. And even if that peace is broken by the tenant, the landlord cannot at that time enter. And so you think, well, the homeowner has no rights. Well, that's not true. What's just happened is the tenant has violated their lease agreement and is now subject to eviction. And so they have every right to stand their ground, except when it means excluding the landlord from caring for their property and giving reasonable access. And so know what your lease says about you accessing the property and enforce your rights. If you have a stubborn tenant who will not let you in, again, bad sign. It's going to put your property at risk. And so you need to enforce your lease and possibly evict someone, even someone who pays rent, because they're not allowing you access to the property. Access to the property is a key and absolutely necessary enforcement, again, especially with an emergency repair.
Yeah. I have a couple of follow-up questions, but I just tell you the bonus material. If you're a RIA member, you can hear that because we're going to be covering all of those. The last question I have is what problem clauses and leases should we never have?
Well, these are the harder ones to pinpoint. I'll tell you the section in a lot of written leases that gets landlords into trouble is the special provision section, because it's blank.
Now, it's blank, and is it because they write it sloppily, or they put in things that can't be enforced, and then that draws other things under suspicion, like when judges look at things in court?
Both, yeah. It's a matter of you're not trained as as an attorney or a real estate agent with a license where you know where the limits are, and maybe this is your first lease. Maybe you've used the same lease with the same unenforceable clause, for years and years and years. For example, I have heard some landlords who come to me and say, "I don't need eviction help. I've got it in my special provisions. By signing this lease, you waive your right to an eviction trial, and you must give me possession immediately." Well, that's not enforceable. The Texas Property Code supersedes your lease, and it ensures that the only way you can get this tenant out is through the process of eviction. Oh, they tell me. Well, it's still there, and I'm just going to leave it there. Again, unenforceable provisions don't help you. In fact, they could hurt you. A court could sanction you for having a bad provision. Or attempting to enforce a bad provision. Also, in most written leases, there's a severability clause, which essentially says, by the way, if you have anything in this lease that's unenforceable, the court can just cut it out.
Yeah. Well, in our bonus material, I really want to ask you about the leeway judges have. Mm-hmm. And if, Ray has said whoever goes to court with the best paperwork wins. It's generally true. But the judge is there assuming that you're the professional and your tenant is the amateur, and so he has high expectations of you. So that's about it for segment number 2. Thank you, Ernie, for the summary statement. Bad lease is worse than a bad tenant. A lot to think about there. And I must mention Rent Perfect. They operate nationwide and have lots of experience in leases with their app and signature, electronic signature part of that. Keeping up with payments is much easier, and then you can manage some of the things that Ernie is talking about. And this just befuddles many landlords. You can find them on the web, but you're better off spending very little money to become part of the Greater Houston RIA or the Alamo RIA. It only costs you 54 cents a day for one person, and if you join with a partner, it only costs you 36 cents a day. So that's money well spent if you want to avoid some of these problems we're talking about. I want to take a moment to feature another vendor we have, and keeping our wood theme, we have the Lone Star Tree Czar. Whether you require complete tree removal or just one limb or curb appeal and landscaping, the Lone Star Tree Czar has the experience and skills necessary to do the job properly and safely. Their website boldly complains it's like Spider-Man with a chainsaw. They do it all. Full tree service, tree removal, stump grinding and stump removal, lot clearing. They do drainage control and installation of root wall barriers. You can find them on the web at thelonestartreezar.com, thelonestartreezar.com. So before we go to our last statement, you can find us at lonestarria.org. To find Ernie, you go to attorneyeg.com. Now, our third and last statement. If you run your leasehold like a business, then an eviction should not wreck your profit. Again, if you run your leasehold like a business, then an eviction should not wreck your profit. Ernie, I know you have lots to say on this, but not everyone you deal with is familiar with the eviction process until it's really thrust upon them. I know from your talk last week, you had lots of experience educating clients. Could you walk us through the process and what does an eviction look like?
Sure, I'll give you the quick run through of eviction because it is a necessary tool that landlords will need to know something about, and if you carry it out expeditiously, you'll find that you can recover property quickly. So the first thing you have to do is you have to determine the default. If there is a default, you have to give notice to the tenant. Typically, this notice is a notice to vacate, and typically it's due to non-payment of rent. That's what most evictions are about, non-payment of rent. If you've waited 3 or 4 or 5 months before you've sent this notice, you're losing money. And so that's not an effective way to stay profitable. If within the first week of a non-payment you have delivered this notice, number one, you're likelier to collect it. And number two, if you begin the process that soon, you're likelier to reduce your losses. Remember, you're holding probably 1 month of rent on deposit. So it's possible to recover your property for a minimal loss and apply that security deposit to the unpaid rent for that month, but not if you don't begin the process quickly.
Yeah, so you really need to look at it as money on the table, basically, because when time goes by, you're losing just more money.
Absolutely, absolutely. And then the snowball effect kicks in. If they didn't pay the first month and the problem that caused non-payment persists into the second month, you can anticipate that the second month also will go unpaid. This way, if you've begun the eviction process during the first month, even if the second month is not paid, but if you can recover possession within that second month, then again, you're limiting your losses. And again, you may not ultimately cut your profit.
Wow. And I think of the 2 instances we had in which we leased a house to a friend, and then they had trouble. And then we had grace, and there was more trouble. And it just mounted. In one of those cases, they paid up. In the other case, we just ended up losing a good deal of money there. So things can drag out, though, if they appeal the process. Can you talk to us about that and kind of what perils it might be there?
Sure. So one thing that landlords don't know is they'll take their case to the justice court and they'll win a judgment, and they feel that because they have the right paperwork, they won a strong judgment, that it ends there, that there's no basis for an appeal. Like, I followed the law to the letter. Unfortunately, in the state of Texas, every single judgment that comes out of the eviction court is subject to an appeal. It doesn't matter how perfectly the landlord filed. It doesn't matter how terribly the tenant was in default. Every judgment that comes out of the justice court is appealable by matter of right.
Well, so how do we prepare for that?
Well, if you know the rules, you can use the rules in your favor. So if, for example, a tenant loses for non-payment of rent and you receive a judgment, generally speaking, there's one of 2 paths that they'll take. Either A, they'll pay a cash bond to secure the judgment on appeal, or B, they'll fill out an affidavit that will allow them to proceed on the basis of payments into the court registry on a regular basis. That first payment is rent for that current month, and then subsequent monthly payments go paid into the court registry. But too many times landlords come to me deep into the appeal process, and the tenant hasn't made any of these payments, and they don't know that the moment they miss that first payment, you as a landlord are entitled to immediate possession. A writ for immediate possession means that the judge signs an order and the constables come out and forcibly remove the tenant in a much faster process than you can waiting for your trial to get to appeal. But if you don't know the rules, you don't know how to use them in your favor, it could mean you collect a check at the end of your appeal process, or you collect possession before the matter ever gets to the appellate judge.
Well, it sounds like a ninja tip there. I mean, that's big. And so time is really of the essence on the landlord to act quickly.
And knowledge. A landlord who doesn't know their rights can't enforce them.
Wow. So you alluded to this. Can you give me an overall timetable for these so someone
Sure.
going in can kind of understand? Because some things are just really absolute, like 21 days or et cetera.
True. So pre-pandemic, the eviction process in the Justice Court was limited to 21 days by statute. The Texas Rules of Civil Procedure said your eviction trial will happen within 21 days of filing. Well, those rules are out the window momentarily. I'm sure that eventually we will be reestablished. But on average in Harris County, we're looking at about a 30-day turnaround. Now, that's not universal. There are some courts that are still taking multiple months to set these trials. They are so far behind. And with COVID protocols, it is much more complicated to run all of these evictions. And so we say about 30 days. Some courts are quicker. Some courts are lagging a little bit behind. But about 30 days for a justice court eviction from filing to trial. As for an appeal, you're looking at about a 1 to 2 month delay. So from the moment of an appeal, you can expect at least 1 month before you're in front of that appellate judge, which is why it's necessary to know the limitations here, to know what obligations does your tenant have. Has the tenant met those obligations? And if not, what can you do? And so we're going to get into the weeds if we get too deep into the procedure. But within that 1 to 2 months time, you could actually, again, recover possession before the matter ever reaches that judge. And then finally, with regard to a writ of possession, which I spoke of earlier, which is that order from a judge to physically remove, these are the constables that come out and physically remove people and property from a premises. That process in practice takes about 2 to 3 weeks. We call it immediate possession, but nothing that runs through county government is immediate,
Right.
Except for maybe the due date of your taxes. All right. And so the constables will post a notice. They'll literally tape it on the door, and it says you got 24 hours to go. And I'll tell you that 99% of tenants who see that, they bolt. But you have that 1% that's going to stick it out, and they're going to make you wait the full 2 to 3 weeks. Right? And they will be forcibly removed, and you will recover possession of your property, but you're going to have to wait out that time. So you might win a judgment, they might not appeal, or they default on appeal, and then you still got to wait 2 to 3 weeks, even after the court has signed that writ of possession. It's a process, but in the end, you will recover property.
What about if they won't get out? I know that it's popular to think, okay, well, we'll give you $500 if you move out. What are the legal ramifications and impact on the lease if you want to do something like that?
I've seen that happen. I've seen that happen successfully, and I've seen that go really, really wrong.
Wow.
So you'll want to position yourself in a way to make sure you're giving money. They call it cash for keys, right? And so if you're not actually getting keys, you're not giving over the cash. Right? And so you can have something in writing established with your tenant that says, on day X, if you have cleared the unit and given keys to me, upon your exit, I will give you Y number of dollars, right? And so that approach works best because there's a motivation for the tenant to vacate in exchange for money. And you're motivated to pay the money because getting possession is much more valuable than the money you're otherwise spending. Where I've seen it go wrong is where landlords continue to trust their tenant, and the landlord pays the money first as the motivation for the tenant to move, and then the tenant fails to move. And unfortunately, when that happens, you're in a tough spot because you stuck your neck out and they had no skin in the game themselves. And so now you're beginning the eviction process when if you had started it from the moment of default, you might not have had to pay any money.
Right. Horrible price to pay.
Mm-hmm.
So, we're coming toward the end here. So anything else you want to tell us about the eviction process, and your relationship with, and I guess maybe some of the horror stories and maybe some of the success stories. As an attorney, oftentimes you don't see the success stories except on Facebook pages, but because they followed your advice. But what do you have to say about that?
So, well, I want to say that the appeal process in an eviction is much more formal than in the justice court. In the justice court, it's easy peasy. You take good paperwork to the justice court, and generally speaking, you're going to win the day. Most evictions are very successful in the justice court level. Right? I'd say about 75% of them are wins with no appeal. It's that 25% that get into the appellate court or the courts of appeal downtown here in Houston, Harris County that can pose a problem.
Well, 25% seems to me like a high number for something like eviction. So this is routinely processed by probably a good number of attorneys in town, yeah.
You would think that with numbers that high, we'd get a lot more of these cases, but generally speaking, the appeal is filed for one of two reasons. Number one, just to buy additional time, or number two, because there's a valid defense to post. But most of the time, on appeal, the tenants will have left. They know they have 1 to 2 additional months. They use that time to pack up and leave. And what ends up happening is that landlords who don't follow that judgment into the next court lose the original judgment. They don't know this, but that original judgment, by virtue of the appeal, is gone. So guess who doesn't have an eviction on their record? Your terrible tenant. Now, you're happy because you got possession back, but the record is incomplete. And so I always urge landlords to go and get that judgment, to make it stick, because if you don't, that tenant's never going to learn a good lesson. They've learned how to game the system.
Wow, that's why you were so emphatic in our meeting, trying to get these guys to really just follow the lease and do that up front. So,
Absolutely.
Yeah, now what you said really makes a lot of sense now. So unfortunately, we need to wrap up our program today. Thank you, Ernie, so much for taking time out of your schedule to educate our audience. This recording will be available on iTunes and Spotify under the MassivePassiveRadioShow.com. Those are the search terms, MassivePassiveRadioShow.com. You can find us on YouTube by clicking on the link found at LoneStarRIA.org. And, of course, Eddie's site again is attorneyeg.com. Again, if you're a landlord, our landlord focus groups meet on March 28th in San Antonio and March 29th in Houston. You can go to LoneStarRIA.org and get that information. We will be publishing our bonus content available to members only. And with that, any parting words there?
I just want to, show my appreciation for you guys having me here, and for anybody who's interested in more information from me. Again, attorneyeg.com. I'm Ernie Garcia, a landlord attorney, and I'd be happy to talk to any landlords who are interested in setting up a consultation.
Great, thank you, Ernie. And we're about out of time, and I'm still getting used to the clock beginning and ending here, and this has been a new experience for me. I've really enjoyed it. Ernie, I've really enjoyed talking with you on this, and so go to LoneStarRIA.org and join us in our quest to become better investors.
Awesome.
Thank you.